Okay, everyone, welcome back after the break. So before the break, we were discussing about the responsibilities of employers. Now, as we discussed earlier, that the ILO, it has a convention called C-155, the Convention on Occupational Safety and Health, and Article 16 of this convention, C-155, it identifies the obligations or the duties placed on the employers. So these are very, very important. And in the recent exam, okay, there was a question related to these responsibilities. And I'll discuss the question in a separate session as well. But just to give you an idea, the question that was asked was regarding a given scenario. Now, the question paper, basically the exam format is in such a way that you guys are given a scenario, and in that scenario, it is the entire situation of an organization is described. Okay, so it was told that the workers, they were not given adequate training, and the workers, they had what you call it, they carried out activity which was unauthorized and a person got injured, and an entire scenario was given there. And as per the scenario, you were supposed to identify which of these requirements, okay, which of these obligations had been breached by the employer or had been contravened by the employer. So these are the kinds of questions which will come in the paper. So there won't be a question in the paper to identify the employer's responsibilities as per Article 16 of C-155. No, the question will be conceptual. So that is why I said you don't need to rote memorize everything. You don't need to read and remember. No, you don't need to remember anything. You need to understand the concept, and you need to understand where to find the answer. So the question in the scenario was to identify which of the obligations or which of the responsibilities as per Article 16 of C-155 did the employers breach, or they were contravened. Okay, so basically what you have to do is you have to go back to the book, read these things, and verify whether they have been breached in the scenario or not. So this is how you would answer the question. But anyways, moving on to the employer's responsibilities, starting off with the first and foremost requirement, the Article 16 of C-155, it says that all employers, they must ensure that the workplace, machinery, equipment, and work processes are safe and without risk to the health of the workers. Okay. Now, this is one single statement, but it is a very broad statement. Okay, it is a generic statement and a very, very big statement. There can be so many issues related to this one statement. For example, ensure that the workplaces, machinery, equipment, and work processes are safe and without risk to the health. Now, in case a worker has provided a workplace, okay, and in that workplace there is a lot of vehicle movement, okay, and there is a lot of vehicle movement and people are crossing the road, and there is a vehicle pedestrian interface, and there are no control measures in place to protect the people from these vehicles. Now that situation is a contravention or breach of this requirement. How? Because this says that the employer must ensure that the workplace is without risk to the health of the workers. Now, if you have not given any barrication or any pedestrian walkway, or if you have not segregated vehicles and pedestrian, this requirement has been breached. It has been contravened. Similarly, the employers, they must ensure that the machinery provided is safe. If you have provided a machinery to the workers and it is in poor condition, or it is unsafe, it is dysfunctional, you are in breach or you are in contravention of this requirement. So in the scenario which I was talking about, the employer had given a paper compactor, okay, a cardboard compaction machine, and its safety gate or safety barrier it was dysfunctional. Now that situation refers here that you can say that the employer has failed to ensure that the provided machinery is safe and without risk to the health of the employers. Okay, so the employer failed to fulfill his obligation. He was supposed to provide a machinery without risk of injury to the health of the workers. However, the machinery which he provided, the safety gate is not working, so it is a contravention of this requirement. Okay. Similarly, you have to provide safe equipment. If you provide damaged equipment, again, you are not fulfilling your responsibility. And work processes, they are safe and without risk to the health of the workers. So work processes also, and by work processes, we mean the work methodology or the work procedure, how the employees are going to carry out the work, in what sequence are they going to carry out the work. So if any of these requirements is unfulfilled, you are in breach of these requirements, you are in contravention of these requirements, and you will be liable to the implications of the breach of these requirements. Okay. Okay, also the employer must ensure that the chemical, physical, and biological substances and agents are without risk to the health when protective measures have been taken. So chemical substances, what are the chemical substances that we use at work? We use paint, we use thinners, we use battery acid, we use cement, we use silica, we use cleaning chemicals, even cleaning chemicals in the office. Okay, the Kleenex and all that. So all of these chemicals, they must be without risk to the health of the workers when protective measures are taken. And if you have not provided adequate measures or adequate protective measures, then obviously you are in breach of this requirement. Okay, physical substances. What are physical substances? Physical substances in the workplace can be of many various forms and natures. There could be certain physical aspects of the workplace, such as noise, vibration, physical equipment, machinery, all of that. These fall under the physical substances. Then there are biological substances. What are biological substances? For example, if you're working in a hospital, or if you're working in a laboratory where you carry out tests, etc. So you will be dealing with a lot of biological substances. For example, you will be carrying out blood tests. So the what you call it, the contaminated blood, that is a biological substance. It may contain various bacteria. It may contain various viruses. Okay, or even in your normal workplace, there might be fungus or other bacteria or germs available. So the employer, he must make sure that the workers are protected against biological substances as well. Then you need to provide adequate protective clothing and equipment to prevent risks of accidents or adverse health effects. So these are the responsibilities placed on the employer as per Article 16 of C-155. And if you are in breach of these requirements, if you are in contravention of these requirements, you are liable to be go through the implications. You might be fined and you might be imprisoned, and so many other implications are there. So these are the responsibilities of the employers as per Article 16 of C-155. Okay, moving on to the employer's responsibilities. There are further responsibilities which the standards place on him. So basically, everybody is responsible for their own safety. However, but the ultimate responsibility of protecting the employees lies with the employer. Okay, how the employer has to protect his workers? Number one, by providing a safe place of work. Okay, if the employer has not provided a safe place of work, it means he has failed to fulfill his responsibility. He has failed to fulfill his obligation. Then the employer must provide safe plant and equipment. What do we mean by plant and equipment? The plant and equipment is all the equipment and machinery that we are using at our workplaces. For example, the equipment and machinery that we use in the workplace, it might include generators. Generator is a plant. We might be using welding machines, welding plants. We might be using compressors, air compressors. We might be using various construction equipment, including loaders, dozers, power shovels, JCBs, equipment such as JCBs, excavators. So there are so many plant and equipment which are provided in the workplace, and it is the employee's responsibility to make sure that that plant and equipment is safe. Okay, so safe place of work, safe plant and equipment, and safe systems of work as well. So the employer's responsibility is also to provide a safe system of work. What's a safe system of work? A safe system of work basically consists of a written formal procedure in which you can identify the hazards related to the job, and you can identify the safe working methodology, okay, to create a safe working environment. That is called a safe system of work. There are many safe systems of work which we use in our organizations. First and foremost is the permit to work system. The permit to work system is a safe system of work. A job safety analysis, a JSA, it is a safe system of work. Carrying out a risk assessment, okay, or developing a safety procedure, these are all called safe systems of work. So we need to have various safe systems of work in place. The employer also needs to provide training, supervision, and competency of the staff. So if the employer has not provided any training to his employees or the workers, he has failed to fulfill his responsibility. He has failed to fulfill his obligation. Okay. Supervision. How do we define supervision? Obviously, when there are a number of workers working, you need someone to oversee them. You need someone to control them. You need someone to manage them. Otherwise, there will be conflicts with one another. There will be fights with one another. Everybody would be doing things in different ways, in different directions, and it would be chaos. Okay, so you need to provide adequate supervision to organize, to manage, and to supervise the workers, and to ensure that they are working properly. Okay, and you also need to ensure the competency of the staff as well. Competency we'll discuss later. It is not only any qualification or not only experience, it is a combination of the skills, the knowledge, the ability, the training, and the experience. SKATE, SKATE, skills, knowledge, ability, training, and experience to do a job that makes you competent. And it is the employer's responsibility to ensure competent staff. Okay. For example, how does he ensure competency of staff? Obviously, when we do recruitment, we carry out interviews, we carry out pre-employment checks, we look at the qualifications of the person, we look at the CV of a person, we look at his previous experience, we look at the training and certification he holds, we carry out technical interviews to find out whether the person is competent or not, and we look at his experience as well. So these are all the things that we do in order to ensure competency of our staff. Now, once you hire them, then you need to maintain that competency as well. How? By regularly giving them training, by making sure that their skills are improved when they are working with you. So this is a continuous job. You need to verify competency of staff before hiring them, and you need to maintain their competency when they are on your payroll, and you need to keep on training them on a regular basis, give them information, advice. So all of these are the responsibilities of the employer. Okay, and it is very, very important to have these responsibilities written down somewhere. They should be written down. They should be clearly understood by everyone. Okay, so those were the employee responsibilities as per C-155. Now, Article 10 of R-164, it also provides some additional responsibilities. What are those responsibilities of the employer? Now, as we discussed, C-155 is a policy setting convention, and the R-164, it gives more further guidance on C-155. So as per R-164, the employer needs to provide and maintain workplaces, machinery and equipment, and use working methods that are safe. Okay, so the employer needs to provide a workplace which is safe. He needs to provide machinery which is safe. He needs to provide equipment which is safe, and use methods that are safe in operating those machinery and equipment. If you have failed to meet these things, then it means you are in contravention or you are in breach of these responsibilities. You also need to give necessary instructions, training, and supervision in the application and use of health and safety measures. Okay, so you need to train your workers, you need to give adequate instructions and supervision to use the health and safety measures. Okay, now in the scenario that I mentioned, there was one responsibility that the employer had fulfilled. Okay, the employer had provided a sign on the machinery or the paper compactor which said that only authorized operators should use the machinery. Okay, so they had fulfilled their responsibility. However, the untrained or new or experienced worker, he did not read that sign, or if he read it, he did not follow it, and he went to operate the machinery and got injured. Okay, so in that case, it is not the contravention of the employer's responsibility, but it is the contravention of the responsibilities of the employee who failed to comply with the given instructions. Okay. Okay, so the employer responsibility is to give necessary instructions, training and supervision in application and use of health and safety measures. He should also introduce organizational arrangements relevant to the activities and size of the undertaking. Okay, so very, very important. What are organizational arrangements? Organizational arrangements are that you need to provide an organizational structure. You need to provide written roles and responsibilities to people. You need to tell people what their job is. Usually this is done by giving job descriptions to various people, or normally we call them JDs. Job description is a JD. A job description basically tells you what your roles and responsibilities are within your organization. Okay, so this is an organizational arrangement. Okay, you should also provide other organizational arrangements such as resources. So the employer's responsibility is to provide resources to carry out the activities in accordance to the requirements. Also, the organizational arrangements need to be relevant to the size of the undertaking. Okay, so for example, if you are doing certain activities which could result in first aid cases, the employer responsibility is to have adequate organizational arrangements in terms of first aid kits. First aid provisions must be available. Emergency response provisions must be available. These all fall under organizational arrangements. So it is the responsibility of the employer to introduce organizational arrangements relevant to the activities and the size of the undertaking. So you cannot have one first aid box for 500 people. Okay, you need at least one first aid box for every 50 or every 100 people. So these are organizational arrangements. Okay, provide personal protective equipment, provide PPE. PPE stands for personal protective equipment and clothing without charge to the workers. So this is the employer's responsibility. So you have to provide PPE, personal protective equipment, including safety goggles, hard hat, safety shoes, safety clothing, which includes your coveralls, your safety vest, etc. So all of these PPE and clothing They have to be provided to the workers by the employer at no cost to the workers. So you cannot charge the workers money for providing them PPE. Okay, so this is the employer's responsibility. Ensure that the work organization, particularly the working hours and rest breaks, does not adversely affect the occupational safety and health. This is very, very important to remember. If you put the workers under a lot of pressure, if you extend their working hours, they will undergo fatigue, they will get tired, and they will definitely make an accident. Okay, so you must ensure that the work is organized in such a way that the workers, they don't have to work extra extended hours, they get regular breaks, they get regular rest breaks, and it does not have an adverse effect on their health and safety. Okay, next, employer must take reasonably practical measures with a view of eliminating excessive physical and mental fatigue. This is a bit relevant to the previous one as well. So the employer has to take various measures, okay, in which he can eliminate the excessive physical and mental fatigue. What is excessive physical fatigue? Physical fatigue is if you put somebody in a job, in a repetitive job in which he has to do all day. He's picking up something and putting it on another place. So it is a repetitive job, okay? And it can become very physically tiring. It can introduce a lot of fatigue. Or if you have assigned workers, if you have assigned drivers to carry out a long journey and you haven't given them regular breaks, so they will get physically fatigued and they will get tired. Okay, and then mental fatigue as well. Mental fatigue happens when you don't give them regular breaks, when you don't have enough entertainment, or if you don't have enough, what you call it, breaks in the work. For example, if you're doing continuously one job all day, you will get mentally tired, you'll get mentally fatigued, and a stage will reach that your thinking will be seriously affected and you won't be able to do the work. Okay, so the employer's responsibility is to take reasonably practical measures with a view of eliminating excessive physical and mental fatigue. If he has not done that, then he is in breach of his responsibilities. He is in contravention of the requirements of the R164. Okay, now keep up to date with scientific and technical knowledge to comply with the above. So the employer, he has to keep up to date with all the scientific and technical knowledge. So usually we do this by having a legal and other requirements register, in which whenever there is a new update, any changes in the technical requirements in the scientific field, is there any development, we need to extract that and see how it applies to our work, and then we have to change our work arrangements as well in accordance to that. Okay, so those were the employer's responsibilities. Now, it's not only the employer who has responsibilities, the workers have certain responsibilities as well. What are the workers' responsibilities and rights? Now, the workers have their responsibilities, but they have their rights as well. Okay, the workers have their rights as well. So, responsibilities, what the workers have to do, what is their responsibility, and the rights are what they have to be provided by the employer. Okay, rights are their needs that need to be fulfilled by the employer. So the worker responsibilities and their rights are defined under Article 19 of C155. Guys, please don't draw on the screen. So the workers under Article 19 of C155, there is an obligation on the workers as well. What are the obligations on the workers as per 155 and R164? Number one, to take reasonable care of their own safety. So if I put myself in danger, I am not complying with the requirements of C155, I am in contravention or I am in breach of the obligations that were posed onto me because of R164 and C155. So we need to take reasonable care of our own safety, which means I cannot operate any equipment if I am not allowed or authorized to do so. By operating an equipment which I am not authorized to do so, I am not taking reasonable care of myself. I am putting myself at risk. Okay, so I'm not taking care of my own safety. Similarly, in the scenario which was given in this exam, the worker, an experienced worker, he went on to remove the jam of the compactor of the compacting machine, and he basically removed the safety door and he went inside the machine. He basically did not take care of his own safety and he put himself in the line of fire. He put himself at the risk of being injured. So he was in contravention of the requirements of R164 by putting himself at the risk of injury and not taking care of his own safety. Okay. Similarly, not only yourself, you're not only responsible for taking care of yourself, you are responsible for taking reasonable care of other people as well. Other people who might be affected by your undertakings. Okay. Other people who are working around you, you must take reasonable care of other people as well. Okay. Similarly, in the scenario I was discussing about, there was a new worker as well who had recently joined the company, and he basically was operating the compactor and he was not authorized to do so. So there is another breach here, that the experienced person, he failed to take reasonable care of the new employee. He failed to tell him that you're a new employee, you're not experienced to use this machinery, so don't operate it. Okay. And the new employee, he was in contravention as well because he used the equipment which he was not supposed to. Okay. So he did not take a reasonable care of himself or other people around him. So this is a very, very, again, these articles which I'm showing you, which I'm reading out to you, these are very, very broad. So you need to understand how to apply them to a broad range of situations. Okay, because in the scenario, in the exam, you'll be given a scenario. The scenario will consist of a number of situations. So you'll be given the entire picture of what is going on in the work environment, and then you will be asked questions like this. So another responsibility of the worker is to comply with the safety instructions and procedures. So the employer's responsibility is to provide the safety instructions, to provide the safe working procedures and safe system of work, and the employee's responsibility is to comply with those safety instructions, to follow those safety instructions, to follow those safety procedures. Again, in the scenario in which I was discussing, the machine or the compactor, it had a clear notice, it had a clear sign that do not operate this equipment if you are not authorized to do so. There was a pictogram next to it as well. However, the worker who went and started the compactor, he failed to comply with the instructions provided on that machinery. So in that case, in that situation, the employer has fulfilled his responsibility. However, the employee did not fulfill his responsibility and he was held in breach or in contravention of his responsibility because he failed to comply with the instructions given on that safety notice or the safety sign which was posted on the equipment that unauthorized workers are not allowed to operate it. Okay. Also, you need to make sure that you use all safety equipment properly. This is very, very important. Now, various machineries, various equipment, various workplaces, they have certain safety equipment, okay, for the protection of the workers. For example, if you are using a grinder, the grinder usually has a guard over it. that guard is a safety equipment. Now, if it is provided, then it is worker responsibility to use that safety equipment properly. If he removes that guard and carries out the work, he is in breach of his responsibilities. He is not complying or is not following the article C19 of C155. Okay, so he is in contravention or he is on breach of the article 19 of C155 and R164. Now, in the scenario which I was talking about again, the workers basically, the experienced worker, he went on to clear a jam. So there was a hydraulic ram which was compacting the paper boards, the cardboards, etc. And there was a jam. Okay. Now the experienced employee, he removed the safety gate. He did not use the safety equipment. He removed the safety gate and he went inside to remove the jam and he got injured. So he was injured because of his own mistake, because he was in contravention or he was in breach of the requirements of the Article 19 of C155, which clearly says that he must use all safety equipment properly, and which he failed to do so when he entered the compactor without the safety gate in place and removing the safety gate. So this is how these things apply to your workplace. Also, the workers' responsibility is to report any situation that they believe could be a hazard and which they cannot themselves correct. So if you're working in the workplace and you believe there is something in the workplace which can cause harm. So hazard, what is a hazard? The definition of a hazard is anything which has the potential to cause harm. So anything which you believe can be dangerous to you, it can cause harm to you or your co-workers, it is a hazard, and you must report that hazard. You must report that dangerous situation to your employer, and if you can correct it yourself, good, go ahead. For example, if there is a blade and it does not have a cover, it is unprotected, if you can provide a cover over it, good, provide a cover over it. If you cannot provide a cover on it, if you cannot make that hazardous situation safe, you must report it to the employer. If you don't report it, then you are violating your responsibilities. You are in contravention of your responsibility. Okay, so you must report any situation which you believe could be a hazard and you cannot correct it yourself, so you must report it. Okay, then you must report any work-related accident or ill health as well. So if you're doing work and there is an accident in the workplace, you must report it. You cannot hide any accident. If you hide an accident, you are in breach or you are in contravention of your responsibilities and you will be held accountable for it. You will be held responsible in the court of law. Okay, so it is very, very important to understand, to make sure that the workers, they understand their rights and their responsibilities as well. So these were all the responsibilities of the workers. Now there are some more responsibilities which are stated under Article 19 of C155. Okay, these are, in fact, these are the rights. The rights of the workers include, number one, they must be given adequate information on the actions the employer has taken to ensure their health and safety. So it is the employer's responsibility to protect the workers, to take various actions to protect the workers, and it is also the right of the workers to know, what their employer has done to protect them. What are the actions the employer has taken to protect them? So the employer has to tell the workers. He has to either do an induction, or he can do a toolbox talk, or he can do any consultation session with them, a meeting with them, and tell them that XYZ control measures and XYZ actions have been taken to ensure their safety and health. Okay, usually this is done in an induction. Okay, so you give an induction to the workers, you tell them that we have provided first aid facilities, we have provided drinking water for you, we have provided a clinic for you, we have provided first aiders for you, we have provided training for you, we have provided PPE, personal protective equipment for you. So the employer must inform the workers what actions he has taken to ensure the health and safety of the workers. Okay, also the workers, they must be given the right to necessary training in safety and health. If the workers are not trained, okay, it means they have not been given the right. Okay, so this is a contravention of the article 19 of C155. The employer must provide training to these workers. If he does not provide necessary training to the workers related to health and safety, it means that the workers have not been given their rights, which is a contravention of the C155. Okay, so the workers must also be consulted by the employer on all matters of health and safety and health and relating to their work. So any issue or any matter which deals with the health and safety of the workers, the employer must consult on them. For example, the employer must consult with the workers while arranging new PPE for them, or while arranging welfare facilities for them, to understand what are the needs of the workers and then act accordingly. Usually, one of the most common ways of consultation is by having a welfare committee meeting. So, in the safety committee meeting, all the workers from various levels, workers, helpers, supervisors, manager, everyone, representatives from every level of the organization, they participate in the committee meeting, and there they can consult with the workers as well. There are other ways of consultation as well. You can use a suggestion box. You can have other sessions for consultation. For example, you can have toolbox talks with the workers. You can have meetings with the workers, consultation meetings with the workers. There are many ways of doing consultation. You can consult with the workers when carrying out risk assessment. You can consult with the workers while doing investigation. So you must involve the workers in HSE matters, and you must get their opinion, you must get their consultation. Okay, also it is the workers' rights to be given the right to leave a workplace that has a reason to think presents an imminent danger or serious danger to his life or health, and not compelled to return until it is safe. So the worker, he must be given the right to say no. If a worker feels that this activity or this machinery is dangerous, I am at the risk of being injured, I feel unsafe, as a worker, I have the right to say no. That equipment or machinery is dangerous. I have the right to say no, and I will not work on that dangerous machinery. It is the right of the worker to refuse to do unsafe work. Okay, so it is their right, and the employer responsibility is to remove that danger and make sure the site is safe before asking the worker to return. Okay, and you, as an employer, you cannot force the workers to return to work. Okay, you need to get their opinion, you need to get their feedback, and then only you can ask them to get back to work. So these were the responsibilities, the rights and responsibilities of the workers. Now, obviously, when you have a certain legal requirement, when you have legal requirements, you need to make sure that those legal requirements are enforced. If those legal requirements are not enforced, then they are useless. Okay, so it is very, very important to understand that we need to have various enforcement agencies in the organization or in the countries. So those enforcement agencies, they are responsible for implementation of the law. Okay, in UAE, there are a number of enforcement agencies, including the Department of Civil Defense. We have the police. Okay, we also have OSHAD in Abu Dhabi. We have the Occupational Safety and Health Center of Abu Dhabi. We have EAD, which is the Environmental Agency of Abu Dhabi. In Dubai, we have Dubai Municipality. We have Tarakhis. So where there are various enforcement agencies available, and every country has their own enforcement agency. For example, in UK, In UK, the enforcement agency is the HSE, the Health and Safety Executive of UK. And the Health and Safety Executive UK, this is one of the most renowned enforcement agencies in the world, and they have a very good website. I would suggest you go and visit it. Visit the website. It has a lot of safety information. It is hse.gov.uk. So in terms of enforcement of the legal requirements of the health and safety requirements, there is no global or harmonized standard. Every country is doing their own things. There are country-specific agencies. They might include health and safety enforcement agencies, fire authorities, insurance company, and police. Sometimes they are also involved in enforcing the health and safety laws. Okay, so what are the consequences of non-compliance? What will happen? What will happen if you do not follow the legal requirements? Number one, breach of the health and safety legislation is a criminal offense. Criminal offense means you will be treated as a criminal. If you break the health and safety law, you will be treated like a criminal. Okay, so it's a criminal offense and you can be up for some real punishment. Okay. Now, usually there are two different ways of enforcement. Number one is enforcement action by issuing an improvement or prohibition notice. So if you are in breach of a small requirement of the law, you might be given an improvement notice under which you have to improve the situation in your workplace and meet the legal requirements. But in that case, there will be no work stoppage. Okay. You will only get a notice telling you that you are in breach of XYZ requirement. You need to rectify this and take action. Then there is a prohibition notice. A prohibition notice is issued when there is an immediate threat, immediate danger to the life and health of the employees. The legal inspector, basically, he might come to your workplace. He might see that somebody is about to get seriously injured. He will stop the work. He will prohibit you from carrying out any further activities unless you take actions to make the work safe. So this is called a prohibition notice. So as an enforcement action, you could receive an improvement notice or you could receive a prohibition notice. And these are considered poor performance, poor HSE performance. If you get a lot of improvement and prohibition notices, that is considered poor HSE performance. Then there is prosecution. If there is, total negligence and the organization is found to be not fulfilling the requirements and not listening to the legal inspector as well, the legal inspector can take you to the court for prosecution. And prosecution can lead to very, very serious consequences. The organization might be fined, the individuals might be fined, or they even might be imprisoned as well. And the legal authorities, they have the right, the court has the right to blacklist a company as well. Okay, they will stop your company from doing any operations in the future as well. Okay, so direct and indirect costs, we discussed this already. We will have a small session next week as well. Okay, this is a group exercise. Let's do this next time. Okay, in fact, let's do one thing. Let's take a small break. Okay, we will be back after 15 minutes. It is 4:20 now. So we will be back at 4:35 and then we will start the class again. So let's take a break for 15 minutes and we will be back after the session. Okay.
Thank you.
Okay, thank you.
Thank you, Ji.